Hi, friends. Uh, I feel it is my great pleasure to welcome you back to my lecture series on Unit 6 Intellectual Property Rights. As all of you know that this subject has been introduced by Vishwesvaraya Technological University for MBA part semester 2, MBA part 1 semester 2. This subject is a compulsory subject as a part of research methodology and intellectual property rights. I am dealing with the sixth unit, that is intellectual property right. Myself, Dr. Basaraj Kuchumat, the teacher for the subject uh, research methodology and intellectual property right. Today I am conducting the fourth lecture series on the topic intellectual property rights system in India. In my previous lecture series, I have already discussed about the meaning, characteristics, and the development of intellectual property rights and also the types of intellectual property rights that are prevailing. Today, I am going to discuss with you the intellectual property rights, how the system is prevailing in India, how it is operating in India. Let us discuss today in detail how India is dealing with intellectual property rights. Dear friends, intellectual property right, though it has taken the shape before 600 BC, but the implementation of that seriously came to India only after the globalization. Before globalization, we had a certain copyright acts and all that, but the seriousness of the intellectual property right came after globalization, that is 1991, when foreign companies started entering the Indian economy. They started implementing the protection, they started enforcing the Indian government to protect the intellectual property rights. Then only the foreign direct investment along with the technology started flowing in India. So India started creating more about the intellectual property rights in the country. Let us understand what are the various types of intellectual property rights that are prevailing in India, that are being operated in India as a part of Indian intellectual property rights system. The first one is the patents. All of you know that patent is one type of intellectual property rights. It protects the novel innovations with the industrial applicability for 20 years. India grants approximately 30,000 patents annually, with the pharmaceuticals, IT, and engineering leading the sectors. It means that in patents are the main ingredients activities that are being implemented in India. Patent is protecting the right of the inventors or innovators who have discovered the new product which is physically in existence. Normally, for example, the product or a concept of the product, anything which is identified can be registered under the Patents Act. And once it is registered, nobody can duplicate it. Only it is an exclusive monopoly power of the inventors or the people who have discovered that particular product. As it is mentioned here, around 20 years from the day one of the patent right registration, the rights or the monopoly rights lies with the inventors. After 20th year, for the benefit of the society, they loses the right. Anybody can copy it and use it. That is what the intellectual property rights talks about. That is patents talks about. India is granting approximately 30,000 patents every year with pharmaceuticals, IT, and engineering. In that, pharmaceutical molecules, products, tablets or syrups or injections, whatever it is, pharmaceutical products and information technology softwares and information technology products, maybe hardwares or softwares and engineering related products like physical products, operational part of any new equipments and all that, they are getting patented every year. They are in line. But connected with the management arts, connected with any other things, the intellectual patent registrations are very less in India. Second one is copyright. That is, copyright is protecting the original literacy for, that is, dramatic, musical, and artistic works for creators' lifetime plus 60 years. In our previous lecture series, we have already seen what the copyright is as a part of the intellectual property rights. Copyright is the right of the that is author or a creator of a drama or a creator of a musical compositions or an artist who has created artistic work, the paintings and all that is called as copyrights. This copyright in India is protected for a lifetime of the what you call as the creator or lifetime plus 60 years after the death, where the next generations of the author can utilize that. That is what we call as a Copyright Act. The film and publishing industries and all that will have copyright registrations in India. Third important one is trademarks. As all of you know, that trademark is a part of the business products. It is a brand identification or the words, symbol, or the design which is registered under the Trademark Act. It protects the registered trademarks for the 10 years protection with unlimited renewals. It means that once the product, the trademark is registered, it cannot be copied. It is exclusive part of the brand company which produces the brand. For example, if you see the Parley company, the Parley G, the writing style and the child picture and the combination of the colors, red color with a blue, red color with a golden writings of Parley G and the child figure, and or yellow and white strips product with a Parley G and the lady. These are all the trademarks which are registered. Once it is registered, next 10 years, nobody can copy it. And if the company continues, it can renew the brand, the trademark. Or once the product brand is sold to anybody else, the person who has purchased can use it. So he can renew that. The person who has purchased the brand can renew that and continue the brand. So around 3 lakhs trademark applications are annually received by the registration authority in India, and they are all provided the trademark rights. Fourth one is industrial design. As all of you know that designs of the products may be the part of the machine components which are innovated and discovered by the original owners can protect their industrial designs, which they only can produce it, they only can use it. For example, the shape of the car, the design of the wheel, the design of the bumpers, whatever is newly innovated, which is not the common in the market, which is uniquely designed, can use that particular design for their products only. If they sell it, third party who purchases that can use it. So industrial designs will also have a intellectual property rights for the discoverers and all that. The fifth important one is geographical indications that we already discussed. The products which are produced in India, like the geotag is given to that particular product, like basmati rice. Basmati is a place, name of the place in India. The rice which is produced there, the breed of the rice which is produced will be noted as basmati rice. Darjeeling tea, the tea which is produced in Darjeeling is called as Darjeeling tea. So these are having a what you call as a geographical identification for the products, which are also registered. No third party producing that different kind of a rice putting the name basmati is prohibited, because that is going to deceive the people, because people are buying with the name that is having a specific quality. If it is not there, then that particular quality of the rice, variety of the rice is not accepted. So it is a violation of the act if a wrong person uses the tag of the geographical area. Even Devgad Apus, Devgad Alfonso, or the Ratnagiri Apus Alfonso, these are all the varieties which tag the name of the place. Last one is plant variety. Some type of the plants which are discovered by the farmers with their experiences by certain kind of culture of the seeds and all that is the exclusive rights of the farmers who have discovered it. Nobody can copy it, that variety of the seeds or variety of the plant they have developed. So this is what we call as plant variety related. Apart from this, the circuit designs or the kind of the electronic component design all comes under industrial designs. That is also sometimes held as a separate kind of a discussions and all that. So these are all the things which are registered under intellectual property rights in India. The key intellectual property right legislations, if you see the laws which are passed in India relating to all these kind of things, we can have a just bird's eye view on this. The first, in the year 1970, the Patent Act is passed in India. It has underwent a significant amendments in 1999, 2002, and 2005 to align with the TRIPS, that is trade related intellectual property rights of the international level when they entered into foreign trades, when the globalization is made, when India has become a part of the international summit, all that foreigners started entering in India with the open up economy. So at that time, TRIPS has started dealing with the Indian activities. So the Patent Act, which was passed in 1970, got a lot of amendments, and 2005 is the last amendment which says patents has got a right for the next few years and all that. That we will study in detail in the next subsequent classes. Second important one is the Copyright Act. Before Patents Act, Copyright Act was there in our country. It was passed in 1957 only. That is after the first industrial revolution. That is the first industrial act, which is passed in 1956. Immediately after that, Copyright Act was implemented, modernized through amendments in 1994, 1995, and 2012 again, addressing a digital rights measurement, software protection, and performance rights while implementing the World Intellectual Property Organization, WIPO, which was established in Internet uh, treaties. It means that the copyright was earlier only covering the print media, but today even the publications made through online journals and even through websites and all that can also be protected, which amendment was made in 2012. Any copy that is made from the soft copy of the publications available on the net is considered to be a plagiarism, and that plagiarism can also be detected through certain plagiarism softwares. And anybody who finds it out that the plagiarism has been done, then a lot of what you call a stringent acts are initiated, strict acts are initiated against the person who copies it. So this is what we call as Copyright Act of 1956, got amendment many times, and the last amendment was 2012. Let us understand the third one, Trademarks Act of 1999. The Trademark Act, which was there earlier in 1958, that is replaced by introducing a service mark protection, well-known mark recognition, and enhanced enforcement mechanisms while establishing the intellectual property rights affiliate board. It means that a separate board is created to identify the trademarks, and once the trademark is registered, cannot be copied. In 1958, the trademarks were not that much protected, but in the amendments that have been made in 1999 onwards, trademarks with the specific colors, codes, and all that can be identified through a mechanical device. Similarity of the two trademarks. Once the similarities are identified, the one who creates the copy of the original will be punished under the Act. That is what Trademarks Registration Act of 1999, and it is being envisaged through civil codes for filing a suit for copying the trademarks. Next one is Designs Act of 2000. As you know, the industrial designs which are patented, when the foreign car markets and all that started entering in our country, most of the people started copying it easily. So that to protect that, in 2000, a Design Act was passed in India. It protects the visual appearance of the industrial products for 10 years, that is extendable by next 5 years as per the requirement of the original owners. It means that any new product enters in Indian economy, the innovations or the discoveries of the designs which cannot be copied for the next 10 years. For example, the Brahmos, a kind of design made by India, has got a patent for the next 10 years. No country can copy it without the permission of India, because it is the combination of Russia and India. So this BrahMos cannot be copied. Anybody wanted a BrahMos, they can buy it from India, but they cannot produce the same kind of a technology because the design is patented. So aligning with the international standards for design protection, this act was passed in 2000. And next one is Geographical Indications Act of 1999 that we have already seen. The Geographical Act passed in 1999, where the geographical tag given to a particular product need to be protected effectively. And the associations, organizations can register that geographical tag and they only can use it. Otherwise, using that particular geographical tag and deceiving the people is also prohibited under the Consumer Act in our India. Not only that Geographical Indications Act of 1999, which safeguards the products with the specific geographical origins. Even the Consumer Act can also empower to stop such kind of deceiving the people with the wrong geographical tags. As all of you know that Kanchipuram sari or Dharwad Peda, Belgam Kunda, these are all the tags that are being made. You can produce Kunda, but you cannot call it as Belgam Kunda. Once you call it as Belgam Kunda, the taste, the procedures are to be perfectly followed. So these are all what you call as geographical indications which are made. The last one is Plant Variety and Farmers Act of 2001. In order to develop the innovative abilities of the farmers, protect their monopoly rights to utilize when they spend so much of money to develop a new seeds, new plant varieties. A Plant Variety Act was passed in 2001 to protect the farmer's interest. Any farmer who makes an experiment with a new breed of plant, new breed of the seeds, it is being protected under this act. So this is what the legislation acts passed in India right from 1957 till the date. Lot of acts have been passed in order to protect the intellectual property rights of the Indians and also protect the rights of the foreigners in our country. Next one is administration and registrations. If you see how these are administered and registered in our country, the administration and registration is being done for designs and trademarks, that is Controller General of Patents, the primary authority for the intellectual property administration in India with offices in Delhi, Mumbai, Chennai, and Kolkata, processes over 5 lakhs combined applications annually through modernized e-filing system. That is, there is a controller of patent designs and trademarks having the offices in the metropolitan places where they will help the people to register their patents under the act. So the administration and controlling of that particular activity lies in the Controller General of Patents and Designs and Trademarks. The next one is Minister of Commerce and Industry. There is a Minister of Commerce and Industry oversees of the Department of Industrial Policy and Protection, DIPP, what you call as Department of Industrial Policy and Protection, which formulates IP policy, intellectual property policy, and administers patents, trademarks, designs, and geographical indications. As all of you know, that the foreign direct investments which enters in India with a special route, with the what you call as a special route, the Department of Industrial Policy and Promotions will certify that investment in our country. The proposal has to be passed out. Whenever that proposal has to be passed out, application has been put forward by the foreign investors regarding protecting their new technology that they're coming with the investments in the country like India, where the registration for that particular intellectual property will be made. The patents and all that will be, trademarks are registered there and they are protected by the Minister of Industry and Commerce. The next important two important things are Minister of Agriculture Sciences. We have Minister of Agriculture administers the protection of the plant varieties and farmers rights authority, safeguarding new plant varieties and farmers traditional knowledge. Any new products, any traditional knowledge, indigenous things which they register as the patent under the act, under the Minister of Agriculture, then it cannot be copied by any foreigner or any other state owners and all that, because that particular indigenous variety will be cultivated by them only, so that they can use it in the other market to earn the profit out of that. So forefathers kind of innovations made in the agriculture can be protected for withholding that particular plant variety from copying and all that is administered by the Minister of Agriculture. Minister of Human Resource Development that manages copyright administration to copyright offices. This is a HRD who protects the copyrights in our country. Any kind of a copyrights or office which you want to register and all that, it is a Minister of Human Resource Development, which will have its offices in the different parts of the country where the copyrights can be registered. The Copyright Acts will issues ISBN and ISSN certifications for the publications, and also copyrights authorities for the publishers and the writers. All these kinds of controlled by the Minister of Human Resource Development. If you see the enforcement of the legal rights or the legal remedies of the intellectual property rights, here is the system that we have to enforce. One is civil litigation. Primary enforcement method through high courts and districts courts with specialized in intellectual property benches in Delhi, Mumbai, and Chennai. Any kind of a complaints regarding the intellectual property rights will be handled by the civil legislation, that is by the high courts and the district courts in our country. Though any person who feels that his intellectual property has been violated, he can lodge a complaint and enforce it through the civil legislation and ask for the compensation and penalties for the damages happened because of violating the intellectual property rights or because of copying that. The next important authority is a criminal prosecution department of the judiciary, that is available for trademark and copyright with penalties including imprisonment up to 3 years and fines up to 2 lakhs. So sometimes copying may be maybe sometimes making a kind of a civil problem. When it is a civil problem, penalty will be levied. But if it is a criminal, what is a criminal offense? Whenever you make any kind of a copy or duplication of some products, and because of that, if the public is being deceived and property of the public is damaged or the health of the public is damaged, it is considered as a criminal protection, criminal act. So such criminal acts will be executed through the criminal courts of the district and high courts, because there is a separate bench for the criminal aspects, and it is a violation of intellectual property rights. And if it is affecting the health or property of any individual or any organizations in the country, then it is considered as a criminal offense. It is not only claiming the damages for the person who has copied it or who has made the violated the IPR Act, and he is also subject to undergo a 3 years imprisonment for making such kind of nuisance under the Criminal Prosecution Act. The next one is we have border measures. Border measures is a customs authorities. There is a something authority called customs authorities who will always ask for the copyrights or intellectual property rights while importing and exporting the goods. These customs authorities will always take care that the duplicate products which are produced in the country cannot be exported, or duplicate products of the other countries cannot be imported if there is no license for such kind of products which is authentically given by the original monopoly owner of that particular product. He cannot export or import the goods to our country. That is what the customs authorities in the border will also protect the enforcement, which will also protect the intellectual property rights and enforces the mistakes or damages made. Recent initiatives like the National Intellectual Property Policy, passed in the year 2016, aim to strengthen enforcement through specialized IP courts and enhanced coordination between the agencies. Intellectual property courts should be the additional separate bench to be established in the high courts and district courts in order to only deal with the intellectual property right violations. It will not be mixed with the other civil litigations like partition suits of the land or any other kinds of marriage related problems and all that. It will be separately treated for the purpose of fast track delivery of the justice for the violation of the IPRs. Therefore, these are the various enforcement remedies that we have. Thank you, friends. Thanks for watching this video. Hope this video will help you to prepare for the exams. Normally, the question is asked in India, discuss the system of intellectual property rights in India, where you are supposed to discuss all that intellectual property rights which are protected. Sometimes the question may be asked, discuss what are the legislative acts passed in India for protecting intellectual property rights. There we have to discuss with the from 1957 till 2005 or 2012, whatever the acts we have passed protecting the intellectual property rights for patents, copyrights, and plant variety and all that. We have to you have to write on that. Question may also be asked at the end of that on this particular thing. How the intellectual property right is enforced in India may be asked for 7 marks in the examination, or general question for 10 marks will be, or for 20 marks sometimes 10 marks will be normally. Discuss the system of intellectual property rights in India. You are supposed to write all the contents of the slides. Hope this video will help you to prepare. Thank you, friends. Thanks for watching the video. I will come up with the different aspects in the next video.